Good afternoon, everyone.
Good afternoon.
Good afternoon to all.
Good
Hi,
afternoon.
everyone.
Good afternoon.
I sent some homework for next class
When?
just a few seconds ago. That's why.
Oh, I was just gonna say I didn't see any homework.
No, it's for class.
Okay, all right, thank you.
Okay. So I'll ask you about 3 questions at the end of this one, but I sent you some homework so you could get a little feel of how the questions will look. All right, so everybody had a wonderful week? I guess so.
It was okay.
Yeah, mine was okay.
Oh, wonderful. now
Life
you-
in the living in the bowl and the beautiful. That's what I call my life. It's always a drama going on.
Yes, but at least you're still here.
Yes,
Yeah.
of course. Thank God for that.
Yeah. All right, so today we're gonna talk about company and corporation. Normally I split the class in 2. It's up to you, but you should have your Companies Act in front of you or the IBC Act. Or some people prefer to have both. Okay. So you had an opportunity to read the chapter? Yes or no? I know Lolita read it. Right, Bethel?
Answer that, Lolita.
I was telling someone this morning, I said it's like reading the Bible. You have to figure out what every word means before you can figure out what the sentence means.
No, man, not that bad.
I had a hard time with it, but it is what it is. I'll go through it some more.
Got it, you got it. You got it. Okay, so you know, whenever you form a company, there's always someone who's out there doing what they call promotion. And so when it comes to incorporating the company, you have to understand how that person who is acting on behalf of others, what does that mean? And if you're the person who's doing it, what is your liability? That's what you have to look at. So now let's go to the Companies Act and let's see what it says with regard to pre-incorporation contracts. That's section 22. Anybody care to read it? Pre-incorporation contracts. Go ahead.
Sorry, good morning. I was just testing my my audio.
Oh, you're okay. So in the book, I have set out what the act speaks to pre-incorporation of contract. And it says a person who enters into a written contract in the name of on behalf of a company before it is incorporated is personally bound by the contract and is entitled to the benefits of the contract. So that's the first thing it's telling you. When a person goes out there and they said, my name is John Doe, and I am interested in having a company built on this site, and I'm going to be incorporating a company. Then they go and they start to speak to different companies about the supplies that they will need, the marketing that they will need. They're doing all of that at their own expense. And they're liable for whatever contracts that they enter into. That's the first thing it says. The second thing, second section says, subsection says, within a reasonable time after the company is incorporated, it may, by any action or conduct, signify its intention to be bound. So that means that after the company is incorporated, the company could then decide and pass a resolution to say all acts that were carried out by John Doe have been ratified by us. which means that the liability then goes to the company. Adopt a written contract entered into in its name or on its behalf before it was incorporated. So they can enter into the contract and under their name, or if it was in another name, they can ratify it. So when a company adopts a contract under subsection 2A, the company is bound by that contract, and the company now is entitled to the benefits as if the company had been in existence from the time the contract took place, or that it has been a party to that contract from that time. Because now, because it is incorporated and it is a separate legal entity, it now enjoys the benefits of that contract. And the ratification says that they are the contracting party and they are liable. B, a person who purported to act in the name of the company or on its own behalf ceases, except as provided in subsection 4, to be bound or entitled to the benefits of the contract. So that means that once the company ratifies that contract, then the person who was acting as a promoter no longer has any liability. They no longer have any benefits to that contract. Then it says an exception is made in subsection 4. It says, except as provided in subsection 5, whether or not a written contract made before the incorporation of the company is adopted by the company, a party to the contract may apply to the court for an order under which obligations under the contract may be fixed, or being joint or joint and several for portioning liability between the company and a person who purported to act in the name of the company or on its behalf. And the court may make any order it thinks fit. So now it is telling you this is this. You can go out there and you can act on behalf of a company, but you're personally liable. You can go and act on behalf of a company in the name of the company, even though it's not formed. But that would be on the basis that after the company is formed, it ratifies that contract in that company's name. Now, what is telling you, what the act now says is this: you can actually go to the court, whether you have a written contract or not, and say to the court that I alone, I'm not the only person going to take the liability for this contract. And then the court, based upon what is presented before them, makes a decision as to whether or not it's the promoter and the company or other persons who will be liable. So that's what they mean by apportioning the liability. And then subsection 5 says, if it is so expressly so provided in a written contract, a person who purported to act for or on behalf of a company before it was incorporated is not in any event bound by the contract or entitled to the benefits of the contract. So what they're saying is that within the contract itself, when that person goes out to enter in the contract on behalf of this company before it's incorporated, if there is a provision written in it saying that they're acting for and on behalf of a company before it was incorporated, then they're not exposed to any liability. Any questions? No? So the question is always asked, who is a promoter? What is a promoter? So the term promoter is a term not of law, but is one of business. It usually summed up in a single word, a number of business operations familiar to the commercial world by which a company is generally brought into existence. So a promoter is usually a person in a controlling position with regard to the company's affairs before it is formed and in its early stages of existence. So the promoter is a person who promotes the business as a project through a company. So who is regarded as a promoter? That's going to be the person who drafts the legal documents and nominate the directors, the attorneys, the bankers and agents, or who arrange the pricing of shares or purchase of property for the future company. Any one of those persons can be seen as a promoter. So if incorporating a private company, there is a need to raise capital from the public, then the company is converted to a public company. I want you to read for next class the case of phonogram versus land. think it's lawn or lien. That's my sheet. Who's volunteering? No volunteers?
Where are we?
We're on the second page of Unit 4.
Okay, I'm there, but I don't see what you were saying. You say land or lane. I don't see that.
No, the case isn't there.
Oh, okay.
Yeah. The
Okay,
case is,
I would volunteer to read, but I don't know where it is.
okay, so the name of the case is Phonogram, PHONOGRAM Limited versus Lien. 1982.
That's L-A-I, L-I,
L-A-N-E.
L-I, oh, A, okay.
Yep.
Okay. Okay, lane, okay.
Yeah,
At lane,
yeah.
okay.
Who volunteered just now? That's Jolene? Jolene?
I could volunteer, but exactly, I have to look it up now and read it.
If you can do it now, yes, that would be good.
Okay, I'm trying to, hold on. You see that's PONOGRAM?
PHONO.
Okay,
Phonogram versus Lien.
LAINE,
L-A-N-E.
LANE, okay. Okay, I think I found, oh no, wait. That's not it.
No?
Okay, I think I got it this time.
Okay, go ahead.
Okay. I'm not sure, wait. What came up is something, I don't know if it's actually the facts about the case.
What does it say?
It's on a site called Practical Law UK, and it says, say a company enters into an agreement before it is incorporated. Specifically, the name on the contract is that of the company, but is another 4 days after the contract is signed before that company actually comes into existence.
Yeah,
Since the contract was signed, that's it?
That's it.
Okay, since the contract was signed and the company incorporated, both parties to the contract have adhered to their obligations. Should the new company wish to leave the contract with no relevant termination provisions in the contract, is there any stock to be placed in the fact that the contract was signed prior to incorporation? My gut instinct is that the performance of the contract and the intention of the parties will mean that the agreement is binding. But does the fact it was signed before incorporation make it null and void? I'm afraid we cannot comment on specific circumstances. However, I have set out some general thoughts for your consideration. Under Section 51(1) of the Companies Act 2006, CA 2006, a contract that purports to be made by or on behalf of a company at a time when the company was not being formed has effect as one made with the person purporting to act for the company or as agent for it, and he is personally liable on the contract. The effect of this section is to protect third parties from the consequences of a company that is never incorporated. This is subject to an agreement to the contrary. Express agreement is required to achieve an exclusion of personal liability. Such an agreement cannot be inferred from the knowledge of the parties. See the comments of Lord Denning, MR, and Monogram Limited versus Lane, 1982. This provision also applies to the making of a deed in England and Wales. Section 51(2) CA 2006. Although the section does not deal with the issue, it has been held that a person who is personally liable for a contract is also able to enforce it. You may consider whether the company, once incorporated, could enter into a new contract on the same terms as the pre-incorporation contract. However, note that there must be a clear intention to enter into the new contract. Merely acting on the pre-incorporation contract would not suffice to evidence of the creation of a new contract. For general background on the ability to terminate a contract, please see our practice notes, contract termination. That's what it says on the site.
That's what it said.
Yeah, so it's saying what exactly what we have in the actual legislation is that a pre-incorporation contract can be ratified by the company after it has been incorporated. Can someone look up the case of Newborn, Newborne versus Sensolid, Sensolid? Newborn versus Sensolid, Sensolid or Sensolid.
So, Ms. Archer, it would be
Yes.
in the best interest of a company to ratify after incorporation than leaving it as is and ending up probably having suits being brought because of
Yes.
actions of the promoter.
Yes, or the promoter enter into a contract where it actually stipulates that they're not liable and not entitled to no benefits under the contract. That's another way you can do it.
Okay.
Yeah. Anyone found Newborn?
So, Ms. Archer, I have a question while someone's looking for Newborn.
That's very smart of you.
I would need to keep you all entertained. I can't, just be listening to nothing. I have a situation where we formed a company the latter part of last year. And at the end of the day, the client decided they didn't want the company anymore. So my question is, what is the easiest way to get rid of it? I don't see where we should have to go through the whole exercise of dissolving because it never actually, got up and running. I don't know that we need to have it stricken off because we don't want to, get to the point of not paying the annual fees. Is there another option?
Why don't you sell the company to someone else?
Didn't think of that.
And all you'll have to effectively do is just transfer the shares.
Okay, that's a consideration. Thank you.
Yes. Who has Newborn?
You said it was Newborn versus what?
Sensolid.
Okay, there's a company law site that has written explanatory notes on Newborn versus Sensulit, Great Britain Limited.
Yes, go ahead.
Okay, so Newborn versus Sensulit, Great Britain Limited, 1954. This case is authority for the proposition that a contract purportedly entered into with or a non-existent person is void. In this case, Mr. Leopold Newborn, who was in the process of incorporating a company, entered into a contract to supply the defendant company with a quantity of harm. He, however, signed the contract in the company's name. His signature showed that he was a director of the company. In an action to enforce the contract, it was held that the purported contract was void as one of the parties did not exist.
Mhm.
That's what it said.
Because the judge said Mr. Newborn cannot come forward and say, well, it was my contract.
Mhm.
Fact is that he made a contract for a company which did not exist. And the contract purported to be a contract with the company, and it was not relevant that, as was the case, it was a matter of indifference to the purchasers, whether they contracted with the company or with Mr. Newborn personally.
Yeah.
Now let's look at the duties of a promoter. A promoter is not a trustee. So in equity, a promoter stands in a fiduciary relationship towards the company he is promoting, but he is not a trustee. A promoter is not forbidden to make a profit as long as he has disclosed his interest in the transaction and the company consents to the retaining of the property, of the profit. So let's look at the case of Gluckstein versus Barnes. Volunteer. It's in here, but you could find it on the internet, sometimes in a lot simpler. Who wants to do Gluckstein versus Barnes? Volunteer.
Hi, it's Jolyn again.
Fast on the quick on the draw. Let's go.
Okay, well, this site is called Course Hero. They have some, I guess, a little brief facts on the case.
Go ahead.
It's, the defendants and 3 others formed a group and bought a property for euro 120,000, but they informed the company that they are paying 140,000. Furthermore, the defendants also have promoted a company which they are the directors of that company. The company, they bought the new property, which is for the company euro 180,000. Moreover, the company have invited members of the public to buy their company shares. This have been done for reserve their purchases. I don't know what kind of grammar this is. An amount of euro 40,000 profit was disclosed. However, the company's promoters have made an extra secret profit of euro 20,000. This was not informed to the respective shareholders of the company, but was instead written with an unclear reference to interim investments. 4 years later, the company bankrupt and they had found the additional euro 20,000. The company wanted to recover back this money from the defendants. That's what they have on it. That's Gluckstein and Barnes, 1900.
Yes. So what was the judge's decision?
Let's see. Okay, it says here, further on says issue, whether Gluckstein have intended to make a secret profit. And what was held, the court held that the rescission was no longer applicable. However, the promoters of the company need to give the euro 20,000 secret profit to the company. back.
Okay, so we can come to that principle in a couple minutes.
Okay.
Some to Erlanger. Erlanger versus Sombrero. You see it in your notes? ERLANGER versus New Sombrero. Because the case of Gluckstein brought out 3 points, as you can see in your notes. One is that there had been disclosure by the promoters in regard to the 40,000 pounds and the 20,000 pounds profit to themselves as directors. But of course, this was useless because disclosure must be to an independent board. So don't forget now, they were forming what type of company? It was a public company. The prospectus said that the 40,000 profit did not include profits on interim investments, but the court held that this was not a disclosure of the profit of the 20,000 pounds. And the case also illustrates that liability of promoters is joint and several for recovery of profit, because Mr. Gluckstein tried to defend himself by saying he was only liable for a proportion of the profits. And the House of Lords held him liable to account for it all with a right of contribution against his fellow promoters. So the case of Erlango versus New Sombrero Phosphate Company, and that established that the promoter had to obtain approval from an independent board. So in that case, Mr. Erlanger set up a syndicate which bought an island for 55,000 pounds. The island was said to have phosphate mines, and Mr. Erlanger set up a company to take over the island and its mines from the syndicate. 5 people were named as directors and subscribers, 2 abroad, 2 entirely under Mr. Erlanger's control, and the 5th, Mr. D, was uninformed. The syndicate sells the island to the company for 110,000 pounds. The transaction was accepted by the 3 directors who were abroad on behalf of the company without any inquiries. A prospectus for shares in the company was issued, which was very favorable regarding the scheme, but the true circumstance was not disclosed. That is Mr. Erlanger's secret profit. Members of the public buy shares in the company, which subsequently struggles, and the shareholders discovered the true circumstances. The shareholders removed the old directors and replaced them. The new directors applied to the court to have the original sale rescinded, and the court held that the court ordered the rescission and said that the promoters should have appointed independent directors and should have made a full disclosure of the circumstances. So the liability of promoters as vendors of property may be considered under 2 headings: where the purchase was made before he began to act as promoter, or where the property was purchased by the promoter after he began to act as a promoter, because 2 different circumstances. So in a situation where the promoter purchased the property before he began to act as a promoter, if the promoter doesn't disclose his interest in the sale, the company may rescind the contract. If the company wishes to keep the property, it may do so, but cannot recover the profit. So following the decisions in the case of Jacques Mahler versus Mahler, the remedy is to sue the promoter for damages and tort at common law for negligence if damage has been suffered. Actions may be brought against a promoter for fraud due to a promoter's misstatement. So for example, if the promoter acquired some land in 2010 for $10,000 and became the promoter of W Company in 2011, selling the land to a company for $20,000 through a nominee and without disclosing his interests, then the company may, 1, rescind the contract, or keep the property and recover damages for the promoter's breach of duty of skill and care. Note that if the property was worth only $18,000 in 2011, the company could recover $2,000, but in no circumstances could it recover the $10,000 profit. So B, where the property was purchased by the promoter after he began to act as promoter, the remedy of rescission is available. But if the company does not wish to rescind it, it is possible to regard the promoter as agent for the company when he purchased the property. And the company can recover the profit made by the promoter. And that makes sense because it's after. So in the example above, if the promoter had been the promoter of W company, when he purchased the land, the company could have recovered the profit made, that is the $10,000. Rescission is available if it is possible to restore the company and the promoter to the position they were in before the contract was made. So as where the company has resold a property to a third party. In such a case, the company must go with the contract and sue the promoter for the profit made, depending on the promoter's position when he bought the property, which he later sold to the company. The duties of a promoter to the company are derived from common law and have not yet been fully developed by the judiciary. They are not contractual duties because the company is not incorporated and cannot contract with the promoter. Nevertheless, a promoter can be regarded as a quasi-agent working without a contract, and as such, would a common law or a general duty in negligence to exercise reasonable skill and care in the promotion. If he allows the company to buy property, including his own, for more than it is worth, he may be liable to the company in damages for negligence. If a promoter issues a prospectus, which he knows to be false, so that the company is liable to be sued by subscribers, the company may sue him at common law for damages. In Release and Handley Theaters of Varieties, the court proceeded on the basis of fraud. But since the company does not itself act upon the fraud by subscribing for shares, the decision is felt to be based on negligence. The purchase by a promoter of a business which loses money, the standard depends on the experience and qualifications of the promoter in the business field. Duties are not owed to shareholders who are unable to bring a personal action, unless this relates to the false statements made by the promoter in a prospectus. Trade creditors and debenture holders cannot sue for breach of duty. For example, in Solomon, there was no action by trade creditors, although he did not disclose to them his interest in the promotion. The duties of disclosure and skill and care upon promoters do not end on the incorporation of the company, nor indeed on the appointment of the board of directors. However, once the company has acquired the property and or business which it was formed to manage, the initial capital has been raised and the board of directors has effectively taken over management from the promoters duties will terminate. Payment to promoters. A company cannot make a valid contract before incorporation. So a promoter cannot legally claim any remuneration for his services or an indemnity for the expenses incurred in floating the company. And then I give you the case of National Motor Mail Coach Company Limited. Anyone want to summarize that one? National Motor. I'm trying to see if I can find a simpler version of it. Charlene, what was that site you went to? Coach, what you said it was called?
Hold on, I'm pulling it up. Course Hero.
Course Hero, never heard of it.
I also was on. What is company law revision? eBooks Kenya Co. and Thompson Reuters Practical Law.
Yeah, they're different ones. I can use the same one I have in here. So the company was called Motor Mail Coach Syndicate Limited. It promoted another company that was called the National Motor Mail Coach Company Limited to acquire the business of a motor mail contractor named Harris. The promoters paid out £416 in promotion fees. The two companies were subsequently wound up, and Clinton, who was the liquidator of the syndicate, proved in the liquidation of the National Motor Mail Coach Company Limited for the promotion fees. And it was held that Clinton's claim on behalf of the syndicate could not be allowed because the company was not in existence when the payments were made and could not have been requested that they be made. The syndicate was not acting as the company's agent or at its request. And the fact that the company had obtained a benefit because the syndicate had performed its promotion duties was not enough. So it goes on to say, however, since the promoters or their nominees are likely to be the first directors, the payment will usually be made by the director under their general management powers. So pre-incorporation contracts generally, a consequence of the company having no legal existence and therefore no capacity to make contracts, is that if a promoter or some other person purporting to act as his agent makes a contract for the company before its incorporations, then the company, when formed, is not bound by it, even if it has taken some benefit under it. The company is unable to sue the third party or on the arrangement unless the promoter and the third party have given the company rights of action. The company cannot ratify the agreement even after its incorporation. Unless the agreement has been made specifically to the contrary, it would take effect as one made personally by the promoter or other purported agent and the third party. So pre-incorporation contract solutions to promoters' liability. A promoter may overcome difficulties with pre-incorporation contracts. He may incorporate the company before he makes the contracts, in which case the problems relating to pre-incorporation contracts do not apply. Or he can settle a draft agreement with the other party so that when the company is formed, it enters into a contract on the terms of the draft. And the articles of the company can be drafted to include a provision binding the directors to adopt it. The promoter is never liable here because there's never any contract with him. Or the promoter may make the contract himself and assign the benefit of it to the company after it is incorporated. So here the promoter remains personally liable for the performance of his promises in the contract after the assignment to the company. And fourth, where the promoter is buying property for the company, he may take an option on in for, say, 3 months. If the company, when it is formed, wishes to take the property, the promoter can assign the benefit of the option to the company or enforce the option personally for the company's benefit. If the company doesn't wish to take the property, the promoter is not personally liable to take and pay for it, though he may lose the money he agreed to pay for the option. And fifth, it should also be noted that under section 22, subsection 2, that a promoter is personally liable, and subsection 5 states that the promoter could agree when making a contract that he should not be personally liable on it. And the Companies Act does provide for ratification of pre-incorporation contract by the company after its formation. Any questions on pre-incorporation? Yes, no?
No,
Oh, wonderful. Hold on, I'm trying to find my paper. I have a question. Not the ones I gave you for homework now. A different one. While I'm looking for that, can someone read a summary of the case of Kellner versus Baxter? Kellner versus Baxter. That one isn't hard to find. Jolene, did you find it?
Hi, no, I haven't found it yet.
Kellner versus Baxter.
Okay, I could try to read a part of the summary, the facts.
ahead.
Kellner versus Baxter, 1866. The fact: a group of promoters for a new hotel company, the Gravesend Royal Alexander Company, entered into a contract for wine. The contract was purportedly on behalf of Gravesend, but Gravesend had not at that point been registered. It was a pre-incorporation contract. Gravesend was eventually registered, but by that stage, the wine had been consumed before the money had been paid. Gravesend soon went into liquidation. The promoters, as Gravesend's agents, were sued. The promoters argued that as Gravesend had been incorporated, the contract had subsequently been ratified and the liability had passed to the company.
So that's another case that you could use. Okay, so I have a question. Before the incorporation of Host Limited, its promoter Barry entered into a contract on behalf of the company. The contract gave the unformed company third-party rights. Who is liable if the contract is later breached? I want to say it again. Before the incorporation of Host Limited, its promoter Barry entered into a contract on behalf of the company. The contract gave the unformed company third-party rights. Who is liable if the contract is later breached? House Limited, Barry and House Limited, the shareholders of House Limited, or the directors of House Limited.
Can you repeat that again, please?
Okay, write it as I said. Before the incorporation.
That's what I was going to say. I need to see that in writing.
Before the incorporation of House Limited, its promoter Barry entered into a contract on behalf of the company. The contract gave the unformed company third-party rights. Who is liable if the contract is later breached? A, House Limited. B, Barry and House Limited. C, the shareholders of House Limited. D, the directors of Host Limited.
Barry,
I may be wrong, but I'm thinking it's House Limited because Barry acted on behalf of the company. So he's in fact an agent, becomes an agent of the company.
Mhm.
yeah, but Barry didn't enter into any contract with them. He entered into a contract with somebody else.
But
He
beyond,
gave them,
but on,
he gave
but
them,
on
he
The
gave
behalf of the
them the
company-
company,
option.
but on behalf of the company.
But he gave them the
Is
third party.
it,
He gave them the third party rights,
is it the
but that
promoter?
doesn't mean that they accepted it.
Barry is the promoter.
Would it be Barry?
I didn't give you
Because-
any.
Possibly Barry and House.
Because they're saying that House Limited, they got the third party rights. But isn't, if you have a third party right, you can't sue or be sued?
Yeah, but
Mhm.
Barry gave them the rights. They didn't say that House Limited accepted it. It didn't claim that House Limited entered into any kind of contract with Barry. Barry entered into a contract with another party.
Yeah, Barry did it on their behalf and it wasn't finalized as yet. It say if they was get into a problem before the company was
Before incorporation. yes.
incorporated, yeah. So wouldn't it be on Barry who's acting on their behalf?
Both.
Oh, so it'd be both of them.
Mhm.
Okay.
Mhm.
Both. Okay, so let me see. Write this one down. You don't need too many words. Joe and Fred wish to form a company. So on March 1st, 2020, they filed the appropriate documents with the registrar. On the 10th of May, 2020, they received the certificate of incorporation dated the 1st of May, 2020. Later, they found out the company had been registered on the 4th of May, 2020. On what day was the company incorporated?
The 1st of May, 2020.
Yes, the 1st of May, 2020.
So they received the certificate on the 1st of May, but what date was on the certificate? Is it the same May 4th?
No. It was dated the
says-
1st.
Okay, so the certificate they received says May 1st as well,
Yes.
but the registry has them listed as May 4th.
4th, yes.
I think they would have to go with what the certificate says, right? No?
Yes, yes, it is the date on the certificate.
Okay,
Yes. So you see how easy that was?
yeah.
So look at the homework questions, which I sent you. Everybody should have it, right? Let me go back to that. I gave you 3 questions. Yeah, 1, 2, 3.
I see
4.
4 questions.
Or
Okay, 4. You can answer those. They're not long.
these are due next week, right?
Yes.
Okay.
We'll discuss those in class before we begin the next chapter. Okay, so let's move on. Terms of incorporation. Certificate of incorporation is the document issued by the registrar as evidence that all the requirements under the act are being complied with. That the company is a company authorized to be registered and is duly registered under the relevant act. The Memorandum of Association that contains the fundamental provisions of the company's constitution gives you the name, the type of company, the registered office, the objects, the limitation of liability, the capital, the type and class of shares, and the subscribers. The Articles of Association then gives out the internal affairs and operation and management of the company. It talks about the issuance of shares, transfer of shares, the procedures for meetings, appointments of directors, resignations, removal of directors, accounts, the seal, if you decide to have a seal or not, signing authority, indemnification, and of course, winding up. The Memorandum of Association contains the fundamental provision of the company's constitutions, and I've set out the sections in the act. And these provisions include the name and the registered office and the activities it will undertake, the share capital, and the class of shares. The Memorandum of Association for a Companies Act company. 2 or more persons may incorporate a company with or without limited liability by signing a memorandum and submitting it to the registrar. And the subscribers who sign the memorandum must not be under the age of majority, have to be of sound mind, can't be bankrupt. A statutory declaration by a counsel and attorney that to the best of his knowledge and belief, no signatory to the Memorandum of Association is an individual who is bankrupt of unsound mind or under the age of 18. Must be submitted with the memorandum, and it is conclusive of the facts declared within the memorandum. The liability of the members of the company incorporated under the Companies Act may be limited either to the amount, if any, unpaid on the shares held by them, or to such amount as the members may undertake to contribute to the assets of the company in the event of being wound up. The important information is included in the Memorandum of Association. So where a company is limited by shares, the following information must be included in the Memorandum of Association. The location in the Bahamas of the registered office, information that the liabilities of the members is limited, the authorized share capital and its division into a stated number of shares of a certain fixed amount, information that no subscriber may take less than 1 share, and information that each subscriber to the memorandum shall write opposite his name the number of shares he takes. So where a company is limited by shares, the following information must be included in the memorandum: the number of shareholders, the number of share capital as indicated by the number of shares, and where applicable, the value of each share with which the company proposes to be registered. The Memorandum of Association must be signed by each subscriber in the presence of at least 1 witness who shall attest to his signature. The full name of the company is to be found in the first clause of the Memorandum of Association, be included in the name. And of course, the names can be limited, spelled out fully, or LTD. Under Section 4 of the Companies Act, the name of the intended company may consist of words, remember, combination of words or numbers, and it can also be in a foreign language. So I have a question. Hold on 1 second. See if I can find my question, what I had written out for you. Okay, hold on 1 second. So the Articles of Association of a company must be signed by A, each one of the directors, B, a majority of the directors, C, all the subscribers to the memorandum, or D, one of the subscribers to the memorandum.
Can you repeat, please?
At least
Yeah,
2
can you repeat the
subscribers, eh?
question?
Okay, hold on, she said I must repeat it. The Articles of Association of a company must be signed by A, each one of the directors, B, a majority of the directors, C, all the subscribers to the memorandum, or D, one of the subscribers to the memorandum?
I would say C, all of the subscribers.
Also, another answer just now. What was that? What was the first answer?
I said at least 2 subscribers.
Okay, anybody else?
I say majority directors.
A majority of the directors? Hmm,
That's what I'm thinking. Or, let me see. In the case with the memorandum, the directors are also subscribers as well?
could be.
Okay.
Let me read it again.
Yes, please.
Okay, the articles of association of a company must be signed by each one of the directors, a majority of the directors, all of the subscribers to the memorandum, or one of the subscribers to the memorandum.
All subscribers.
Thank you. That's the all subscribers. So yes, you're right when you said it should have a minimum of 2, but it wasn't asking you how many. It's asking you how many should sign. So you know it is 2, so it has to be all. Because the limit is 2.
Yeah.
You got that?
Yes, ma'am.
Yeah, I got it.
All right. So let's go back to Fred bought some shares in Time Limited on the 1st of February, 2020. So to whom does Fred become bound in contract?
Excuse me, Ms. Archer, if that was a question on the exam, would I have gotten partial points?
Partial. Did you say the word partial?
Well, in reality, it was correct.
Yes. Yeah, correct. You didn't answer it right. So it'd be between.
Me too, because my directors were subscribers.
And I must think that. All right. Listen to this one now. So Fred bought some shares in Time Limited on the 1st of February, 2020. To whom does Fred become bound in contract? A, the company only. B, the members of Time on the 1st of February, 2020. C, Time and those who are at present its members. Or D, Time and those who are members of Time on the 1st of February, 2020. Say it again.
Yes, please.
Okay. Fred bought some shares in Time Limited on the 1st of February, 2020. To whom does Fred become bound in contract? A, the company alone. B, the members of Time on the 1st of February, 2020. Time and those who are at present its members. Or Time and those who were members of Time on the 1st of February, 2020.
Can I say the company?
You can say the company, but it's not right.
The Time and the members.
Which one?
No, just the members, because even if there were members around the same time as Fred, whenever members change out and new ones come in, they're still gonna be members of the company. So it would be, where is he? I think that's C. Time
Yes.
and members.
Members presently.
Yes.
Mhm.
See, I need to give y'all a choice for true. This will be fun. I didn't get no answer there.
I don't know if I agree with that, because Fred is a member as well, so all of them own part of member of partial ownership of the company.
Right?
So
it's
Fred is liable to the company, not the members. Well,
bound to
I
in
guess
contract.
technically, yeah.
Yeah, so he's bound to in contract.
Yeah. Okay.
Okay. All right, so IBC is, where's IBC begin? On this page over here, Okay, for an IBC. Under the IBC Act, 2 or more persons may, by subscribing to a memorandum, incorporate a company. Only persons licensed under the Financial Corporate and Service Providers Act may incorporate an IBC, or under the Banks and Trust Companies Regulations Act. An IBC may be incorporated for any object or purpose other than the criminal object or purpose. And remember now, always remember that the IBCs is one of the targets of the international market. The liability of members of a company may, according to the memorandum, be limited by shares and guarantee, or unlimited. The memorandum for an IBC should include the following information: the name, location of the registered office, the registered agent, location of the registered agent, the object and purposes, the currency, and for a company limited by shares, the authorized share capital and par value of the shares. For a company limited by guarantee, a statement that each member undertakes to contribute to the assets of the company in the event of a winding up during the time he is a member or within a year afterwards. The payment of the debts and liabilities of the company in cases for company limited by share and guarantee. In the case of an unlimited company, a statement that the liability of the members is unlimited, statement of the number of classes and series of shares, the number of shares of each such class and series, and the par value shares with par value, and that the shares may be without par value. Statement about the designations, the powers, the preferences and rights, and the qualifications, limitations, or restrictions of each class or series of shares that the company is authorized to issue, unless the directors are authorized to fix the foregoing. So the full name can be limited, it can be LTD, it could be LLC, it could be corp, it could be corporation, incorporated, it could be GmbH, it could be a sociedad anonima, an SA, any one of those. So under Section 3 of the IBC Act, the name of the intended company can be in words, numbers, and words could be in foreign language. So under the articles, Section 10 and 11, both provisions stipulate requirements for the articles of association of a regular company. The articles will be signed by the subscribers and must be filed no later than 6 months after the issue of the certificate of incorporation. But most people file both the same time under the Companies Act. Under the IBC Act, Section 14 and 15 gives you the provisions related to the articles of association of an IBC. The articles shall be subscribed by 2 persons in the presence of a witness, and they should be filed with the registrar on the same date as the filing of the Memorandum of Association. The articles of association, when registered, bind the company and its members, and the M&A, when registered with the registrar, are placed in a register maintained by the registrar known as the Register of IBCs. A certificate of compliance issued by the consul, an attorney engaged in the formation of the company, or the registered agent named in the Memorandum of Association as the registered agent, must accompany the M&As in order for them to be registered by the registrar. So the articles of association of both types of companies include the following provisions: the shares and transmission of shares, the meetings, the voting rights and the proxies, appointment, resignation, and removal of directors, the powers of directors, the management of the company, the seal, if any, authentication of documents, accounts, indemnification, audit, and the winding up. So for a CAC company, there are some main constitutive documents that a company should have. The certificate of incorporation, the M&As, the share certificate or the share transfer form, the corporate seal, the nameplate, the register of members, the register of directors and officers, the register of mortgages and charges, the declaration of trust if they're held in nominee capacity, the first director's minutes, and the shareholders agreement. And the requirements for incorporation, we went through that process already. This is just a summary where we just speak about the incorporation with the 3 names, and then of course, reserving the names, and then filling out the forms to incorporate the company, providing the necessary due diligence on the shareholders and the directors, and paying the requisite fees. For checklist for a company incorporation, post incorporation, you reserve the company name, you prepare the memo and arts, you prepare the memo and articles association for signature, confirm the copy, prepare the affidavit by witness to the subscribers and arrange to have them sworn and notarized, prepare the declaration by the attorney or the notary public and arrange to have them sworn and notarized, request a check for filing, request a check for stamp duty on capital, prepare a letter to the registrar, order the share certificate book, order the nameplate, order the corporate seal, submit application to the exchange control if necessary, or you could submit the application to the National Economic Council if they are purchasing land or doing an investment in the Bahamas, to pay the stamp duty to public treasury, and then file the M&As. Prepare the register of directors and officers, prepare the register of members, prepare initial directors minutes, prepare the share certificate, prepare the letter to send the documents to the client, including the invoice, prepare the corporate files, obtain the NIB numbers, business license, VAT, TIN number. All of those things need to be done in preparation before the company begins its business. So the main constitutive documents and instruments for IBCs are certificate of incorporation, certificate of compliance, the M&A, the share certificate, the share transfer form, the corporate seal, the management corporate director agreement, the register of members, the register of directors and officers, the register of mortgages and charges, subscribers minutes and appointment of first directors, the nominee agreement, and then the seal log. The 2 items you mentioned, Lolita. Remember in your email?
Yes, ma'am.
The 2 that you wanted added on, which was the CESRA filing after 90 and the annual accounting declaration.
Correct.
Okay. And then the requirement for incorporating an IBC, you know that already. We did that in the other chapters. So what is the effect of incorporation? Once a company is incorporated, what's the effect of that? Remember in the case of Solomon, what did the judge say in Solomon? Once you receive that certificate of incorporation, what does that mean?
That the company is a separate legal person?
Yes. So under section 716 of the Act and subsection 2, it says from the date of the incorporation mentioned in the certificate, the subscribers to the memorandum together with such other persons as may from time to time become members of the company shall be a body corporate by the name contained in the memorandum capable of exercising all the functions of an incorporated company and having perpetual succession and a common seal with power to hold lands, but with such liability on the part of the members to contribute to the assets of a company in the event of it being wound up. All in one nutshell is everything that was said in Solomon versus Solomon. And it also gives you the advantages of actually formulating a company, because it says that it has perpetual succession. And then it says under subsection 3 that a copy of the memo and arts filed and registered, and any extract therefrom certified under the hand and seal of the registrar as a true copy, shall be received in evidence in any court in the Bahamas without further proof. And a company incorporated under this act should at all times maintain a registered office in the Bahamas. So you see, once you've incorporated a company and once you receive that certificate of incorporation, then that company can do whatever business as long as it's valid in the Bahamas. Any business. Any questions so far? Because by the time you finish doing all these filings, I don't know what we'll have left. But
In terms of incorporating an IBC, do you think the country receives as much benefit from that type of entity compared to the international reputation we get?
I was just gonna answer with a one word, and I'm trying to make it politically correct. From my experience and my knowledge, based on how they are used, no, we don't. Not at all. Because even what we charge on an annual basis just to be a registered office, registered agent, and just doing the filings, unless you get the trickle down effect of doing some type of some other service other than that, no. These are vehicles that are used to transact business around the world. So unless you are actually going to get that part of the business, and that anytime they wish to enter into a contract somewhere around the world or do some type of restructuring, no, you don't get any benefit from it at all. Just those flat service fees. So you have to be able to offer other services in order to get the kind of funds that they are generating.
I always wondered that because I worked for an IBC and I just always thought that we're getting pittance compared to what the benefit they have from being here. And I wonder why we continue to maintain and promote this type of company.
Well, if you go all the way back to almost 20 years ago, they would have been created as a way to attract foreigners to come to the Bahamas in order to do business internationally. I don't think it was ever envisioned at that time that we would be making money from it, not that kind of money. But it was done more to attract them to come to the Bahamas for the other things that we offer, which is sun, and sea, buying land. So sometimes they come and they would incorporate an IBC just to hold their assets in the Bahamas. But some of them actually would incorporate an IBC to do more than that. They actually do them to transact business. Instead of in their name, they do it in the name of an IBC, and they do make a lot of money. Now, if we decided now to tax that, it depends on how we tax it, whether they will stay. You see, because the difference is in the US, you could form a company that is similar to an IBC. And you have tax advantages with that because they tell you how to structure it in the United States. But of course, you're filing your tax return in the United States. So there are benefits. So if you get an IBC from here and I'm making money somewhere else around the world and I'm paying taxes to you and I'm paying taxes to my home country, I don't know how that will be received. You understand?
Understood.
Yeah. So it's kind of, it's difficult. So only thing you could hope to do is that we offer other services that they need. Other than that, no.
Like the private industry would benefit from that, from the services they provide and with dealing with the registry and doing all that other stuff and account openings and all that other thing. That's how they would benefit.
Yeah, but she's talking about, like, you could have an IBC that does, let's say they have a commodity and most of them act as middlemen. They're not the major players in a transaction. So they're
Mhm.
middlemen. A lot of them are they bring buyers and sellers together when they have these IBCs. That's most of them in that type of business. And their commission in one transaction could be 2, 3 million, 4 million, 10 million.
Yeah.
You see, and then they're doing that all day long. And depends on how many IBCs they have, how many contracts they have out there. They're making a lot of money. And I understand her point, because if we were getting at least 5% or 3% of that, we'd be making some monies.
Yeah.
Yeah, but we don't make that kind of monies from those at all. Now, if you're part of the restructuring or it was something that they have to do, and they had to pass through the Bahamas, they did permission, which means that it goes through the NEC, and probably had to pay some fees for something. But other than that, no, we don't get those funds from them at all. It's just a vehicle that we provide, and that's it.
Yeah.
That's it. Sad to say, because I know once you get intimately involved, you see the volume of funds, but there's nothing we can do about it. But the international arena, they're not finished with us as yet, so who knows what they'll come back with next. And that's what they're trying to tap into. They're looking at the amount of money that's passing through these companies and who is taxing it. And I don't think it'll be.
Now, I was just gonna say, I totally agree with her. You know, I guess it's just a matter of negotiations too, because for our IBCs, the only thing we basically make are the registered office, registered agent fees, which is pittance compared to, like Ms. Archer mentioned, when you see the volumes going in and out. So I don't know. I just raised that question with someone this week.
And what did they say?
They said the same thing that you said.
Yeah.
They don't see whether there's any possibility to charge anything else.
Exactly. I just bought a product from you and that's it.
Yeah, because a lot of our IBCs actually, you know, are like the starting point for icons and you know, other type instruments. But then there are those IBCs that are just standalone IBCs and they do nothing else. But we are custody registered office registered agents, and we make absolutely nothing on them.
Yep, and they're out there making money. They do it all in the name of their company.
Yep.
I don't think at the time that it was created 20 years ago was thought to be as lucrative as what it is now, because things evolve over time.
Well, that's where we need to make changes in our regs.
Well, the thing is, but this moves with international pressure on one side, and then looking at other centers like ours. Other centers have vehicles just like this. They all have it. So I don't, if I tax, I could come from here and I could open mine in Marshall Islands. I could open mine in Seychelles. I don't have to be here. I could open it in Malta. So it's I don't know. How much money would we lose if the bulk of our IBCs went to another offshore jurisdiction?
Well, sound like we all need to get together All speak with one voice.
Right.
Everybody. Two
I'll have-
conglomerate. Everybody come together and say, okay, we're charging more.
Right, so that'll have to be all of the offshore centers then decided that's what they want to do.
Yeah, I know it's not gonna happen.
No,
Yeah, because when they also advise some of the fees, they put their fees on top of it, so.
Mhm.
Yeah,
But I agree with you. When you look at what we charge for registered office, registered agent, and look at what the ones who are actually using those vehicles as a business vehicle themselves, it is pittance. It is pittance. But then for those who are just using it as a holding company, you know what I mean? Just a box on a piece of paper, they're not gonna pay more money. It won't make any sense. Not to them. It won't make any business sense.
what if the fees were done on like a basis of like the type of monies that come in per IBC, like say if you're in this bracket, this is what the fees would typically be, but as the bracket, you move along the brackets, then it may be up a little bit more.
Yeah, but you're charging me fees and I also have to pay tax.
Hmm.
So I mean, I'm getting
But if
taxed.
the IBC is registered in the Bahamas, that IBC should be recognized Bahamian, and so it should only pay Bahamian taxes.
Really? That way. No. I mean, I understand the argument in order to receive more monies from these vehicles, because yes, they are making money, but how can you justify that? That's the question. How can you justify taxing me? When I'm already,
Because
when I'm,
the company is a Bahamian and all Bahamian citizens have to pay taxes.
yeah, but I'm not a Bahamian citizen. I bought a product from you. That's it.
No, the company is a Bahamian, the company has to pay.
Okay. And so you want to charge me what, an overall corporate tax based on my earnings?
No, based on the company's earnings, because the company is the Bahamian being charged.
Right. So you want to charge me a tax on that. And then
Yeah.
I also have to pay tax on my overall wealth in my country where I live.
But that's your thing. We only tax in the Bahamian, which is the company.
Yeah. No,
We're not taxing you, we're taxing the Bahamian.
but
You know, I think in hindsight, if we educate Bahamians more on IBCs, like the ones that are working there, because when I look back in the last 10 years that I was working for the company, I still as a director, one of the named directors, but you know, I never got anything for being that named director. I got a salary for working for the company, but for having my name out there, I think I should have been paid. But if I had known some things then, like I do now, I think I would have demanded something for having my name, for using my name. So if we
You did-
educate our people.
oh, I see. You use your name rather than the company's name.
Yes.
No, you should have
And that
insisted.
was quite scary for me, especially even now as I look back, because that was an international company and I never really even considered all the ramifications if something had happened with that company.
Mhm.
Because you know they were quite diverse oils, international oil, and then they did a lot of futures and hedging. But my name was out there on their paperwork.
So your name on my papers.
Yeah. If something had really happened, I would have been in some deep trouble.
Yes. Mm-hmm.
But I was young and I didn't know.
Yeah. Yeah, there is some liability. That's why you always use the company rather than the individuals. So you'll be doing the work, but you'll be doing it under a company. So remember that for next time. Don't use the individual name. Your
Yeah, but
company,
that's where the insurance should come in, because if you're going to be a named director, I would imagine, even if you're doing it on your company's behalf, they should have some type of indemnity insurance for
And
you.
you hear the key word you said? Some type of.
Well, yeah, that too, but
Cover everything.
but you shouldn't just be out there.
I agree with you. But sometimes you may just be out there. If the insurance actually said that when you act on behalf of the company, but then you're signing these things in your own individual capacity,
Mhm, mhm.
and that shouldn't be. It should actually be in the name of the company or one of their nominee companies that they have. So yes, you're a director on that nominee company, but on the actual paper, which is filed, it would have the name of the company.
Yeah, but we have a lot of IBCs and stuff that have named directors on the register.
Maybe they're getting paid a little bit more than you were.
Yeah. I know that usually there's be like set out directors fees. I don't know. I don't think the directors just really get like a percentage based on what the company makes.
Oh,
I think
no,
it's just,
no.
oh, it might, yeah, I think it's just the fees would have been agreed when you signed on as a director.
Right. That's a flat fee. Only management would be getting something, or the actual shareholders. No,
Yeah.
no, that's it. But you all gonna argue like the rest of the people on the talk shows, and they were arguing for a raga night and this night and that night. Well, I don't understand that one either. But and business doesn't work that way. No. So that's it for IBCs. So if you want them to leave, the ones who are using them to make money, just tell them you're going to tax them. And then you will see. Of course, if they're using it for, illegal activity, they don't mind paying. So we'll see. Okay, so let's do unit 5, which is record keeping. It's a very short one. So I've just added the two together so it could be, I guess, more complete.
A quick question before we start unit 5.
Mm-hmm.
Had you sent I think it was the course thing is yet?
The capstone, you'll be receiving it this week, along
Okay.
with your mid.
Along with the midterm.
Yes, ma'am.
Okay, thank you. I just wanted to be sure that I didn't miss it.
No, you did not miss it. I've started drafting it already.
Okay, great.
Yes.
Remember, my level is I know nothing.
Really? No, that don't work.
Oh.
I'm here to make you think. I'm here to challenge you. So no. Won't work. Okay. So corporate record keeping, that's normally done by the corporate secretaries. And there are reasons why you need to maintain corporate records. One is to ensure limited liability protection for limited liabilities companies. 2, to make sure that you're complying with statute, legal, regulatory compliance. 3rd is to allow the shareholders to be able to inspect corporate documents properly and adequately. 4, to fully document the shareholders, the directors, and officers of a company and their due diligence information. And 5, to represent current and accurate information on the company, its corporate and financial affairs and shareholding. So let's go through each one of these. The first one is to ensure limited liability protection for limited liability companies. What records do you think you keep for that? What records do you think should be in hand as a part of corporate records to maintain limited liability protection? Wouldn't that be the M&As? And then to ensure statutory, legal, and regulatory compliance. That means that you have to make sure you comply with all of the requirements either under the Companies Act or under the IBC Act. And then any other regulatory requirements from the Registrar General, from the VAT Department, from Department of Inland Revenue, National Insurance Board, all those things. You have to make sure that you have records on file for those. Allow shareholders to be able to inspect corporate documents, which means that your documents must be filed, neatly filed, pages numbered, so you make sure you know there's no missing information. Fully document the shareholders and directors and their due diligence information, which means you should have a folder that has all of the KYC information on all of the directors. So that's a copy of their passport, a copy of their address verification. And then of course, you should have another folder that keeps the actual financial accounts.
And then the CRS form is now a requirement.
And then your CRS form, yes. Yeah, for each one of those.
And the
CRS.
W form, whether it's US or non-US.
Yes. So you need those also. So for record keeping under the CAC, Section 17(1) says the company incorporated under the Act must maintain a registered office at all times. The address must be filed with the M&As with the memorandum within 30 days of incorporation. And the directors of the company can change the address of the registered office and notify the Registrar General of the change of address. A company must prepare and maintain the following corporate records at the registered office: the M&A and any amendments to it, the minutes of meetings and resolution of shareholders, the copies of any notice, and any register, such as the register of members or the registers of officers and directors. Under Section 6, the register of members must be kept at the registered office. That would include the name, the address, and occupation of the members, the shares held by each member, distinguishing each share by its number, and the amount paid agreed to be paid on each share. The date at which the share of any person was entered on the register, and the date on which any person ceased to be a member. The register of members, subject to such restriction as may be imposed by directors, may be inspected by members of the company and any member of the general public, and upon payment of such fee as may be determined by the directors. The register of members may be in such form as the directors approve, but if it is in a magnetic, electronic, or other data storage form, the company must be able to produce legible evidence of its contents. In addition to that, you must have an annual list requirements, the filing requirements of the annual statement, the annual returns, whether or not 60% of the shares are beneficially owned by Bahamians. You get the annual accounting declaration, like Bethel reminded me I didn't add it in here. And then of course the sales profiling. And then publication of the company name at the registered office. The IBC, of course, is much simpler. Of course, it must have a registered office. The registered office must be, the name of the address of it has to be submitted to the Registrar General. The directors of an IBC may change the address of the registered office and notify the Registrar General within 14 days. The IBC also must have a registered agent. A person cannot act as a registered agent unless, of course, they are licensed under the Financial Corporate and Service Providers Act or under the Banks and Trust Companies Regulations Act. The name and address of the registered agent must be submitted to the Registrar General for registration at the date of incorporation. And of course, the Registrar General maintains a register of registered agents. And subject to the Companies Act, companies and IBC must maintain a share register at its registered office. And IBC is required to keep a share register also at its registered office. And it is not required to file a share register with the Registrar General. Section 29, subsection 1 specifies the information required to be contained in the share register, and failure to keep a share register is an offense and a penalty of a fine of up to $10,000. I don't know of anyone who has been fined. Anyone knows of a company that is fined because it didn't have a share register? Not saying that they all do, but do you know of any that was fined?
I'm not aware of anybody who actually checks that. 'Cause, I mean, I know the SCB does inspections every now and then, but I've never seen any inspection from the Registrar General.
No,
So
I've
I'm
never.
just wondering who would do
You're not
that.
supposed to provide the registry with the register of shareholders. They only give them the director.
Register of directors they require,
Yeah.
not the register of members. So I
Yeah,
was
you
just
don't give
wondering
that
who would
to them.
actually check that.
Yeah.
What compliance commission?
No. You don't.
I mean, they're the only ones.
See, that's where we lose opportunity for revenue.
Yes. I'm sure many companies don't have it.
Yeah, because that's not something you have to give them.
Right. But it's something that you should have.
Yeah, you could have it, yeah.
Yeah. But the question is, do they have it?
I mean, even if someone was to say ask, you could just hurry up, type it up, eh?
Exactly.
They hold on.
I think most companies have them though. They're very simple. So I can't imagine someone not having them.
And then you admitted that you didn't, like, I don't know.
Exactly.
And of course, you have the register of mortgages and charges. So by law, an IBC must maintain a register of directors and officers. And IBC is required to keep that register of officers, and that contains, just like under the CAC, the name and addresses of the persons who are directors and officers, the date when they were appointed, and the date when they ceased to be a director. The register of directors and officers may be in such form as the directors approve. So that means it can be in electronic form. A copy of the register of directors and officers shall be filed with the Registrar General and open for inspection by the members of the company. And what else? Under the IBC Act amendment, the register of directors and officers must be filed within 12 months of appointment, and a requirement for inspection of company records by a member or by an attorney. And that's it for record keeping. So of course, he added on the 2 points that Lolita gave us: SESRA filing and the account declaration.
Just one more thing I wanted to add, Christine, with regards to the KYC requirements. Recently, well, I guess I could say recently, but the passport copies and address verifications are required to be certified.
Yes.
And in a lot of cases, you know, people have strict requirements as who can do this certification, whether it's an attorney, a banker, or notary public, or whatever, but definitely they would have to be certified.
Yes, they have to be certified. Yes. Now the list as to who can certify it, it is not exhaustive. So each organization can make their own determination besides an attorney. Yeah, they can find what they want, depends on the jurisdiction as to who can certify it. And then for address verification, as long as it is an electronic bill and it's not being tampered with, we accept it. So you don't actually have to have that, doesn't have to be notarized or certified. As long as it's electronic billing, we will accept it as it is.
Miss Archer? No, sir.
Miss, I wasn't even gonna say, I wasn't going there in this caucus. My
No,
compliance
sir.
people.
Look here,
on
they
that
want
run.
it right. And basically now everything has to be certified.
Why?
The Cayman Island is like, they hard pressed on that. Even the POAs have to be certified.
Why?
And even here, because I'm not gonna call the
And a
bank
lot of people
company.
have company policies where they prefer it to be certified, because even if it's digital, there's such a thing as Adobe Pro. Like you could PDF complete and change things if you wanted to.
Yeah,
that's what it has to be. Okay, if you have your clients from a certain jurisdiction, that jurisdiction is one that you're familiar with. You should be able to determine whether that is an authentic bill or not. You know what, okay, if you're here in the Bahamas, you know exactly what a BPL bill looks like, correct? It
Yes.
doesn't change one format, right? So if you're familiar with clients from a certain jurisdiction, you know what those bills look like. If it is an unfamiliar, then of course you'll ask for it to be notarized.
Yeah, but what I was saying is it could be a legit, like it could be from BPL, okay, Bahamas, but you could change the names and the details on it on an if it's electronic, it's even easier to change it.
Mm,
Ms.
Like if it
Hodge,
was generated electronically, it's even easier to tamper the document and change it to say whatever it is you want it to say.
but there's still a way to check that, you know. Because once you receive the application along with the supporting documents, once you key in that person's name, you would always get an option where that person's name comes up and their address.
Mhm.
Because I've had one where this person put their name and their address. And when I went on the internet, I found out that that person did live at that address, but that was 4 months ago.
Mhm.
And they had moved to another address. So I just sent it back. Can they clarify exactly where do you live?
Yeah. Wasn't current.
Yeah, it wasn't current. They used the old address. Why did they use the old address? Because one of the supporting documentation they sent only had the old address on it. So they wanted it,
They moved to Panama.
yeah. Instead of just, one of my identification is here, but I no longer live there. But I now live here. No, they sent it and tried to put everything in one address. And they
Mhm.
don't live there. So you could find it out.
Okay.
Yeah. You could find it out. All right. So let me get cracking so I can finish this capstone for you all and write your midterm. You have some homework for me. You can send it anytime during the week and we're gonna discuss those next Saturday. Okay, which date did we agree for this homework, for this midterm? 2 weeks?
Yes.
Hold on, let me see.
Okay, there she date. I'm looking for my paper too.
Yes, I think you said 2 weeks after the,
You said to
after you give
return
it to
on the
us.
26th of Feb.
I have it right here. Yes, I said 26. I'm sticking to that. Yep. I'm sticking to the 26th. All right.
Oh, that's 3 weeks. No, because we didn't get it yet. We were supposed to get it today.
Yeah, you get it sometime just between now and this week, you will have it.
Okay. Thank
Yes.
you, ma'am.
Okay.
All right. So enjoy the rest of your weekend. Do my homework now so you don't have to rush it on Friday.
All right.
And we'll discuss that at the beginning. All right.
Okay, bye, everyone.
Okay.
Bye,
Bye.
okay,
bye.
bye-bye. Have a safe weekend.
All right.
Bye-bye.
Bye, everyone.
Good afternoon, everyone.
Bye.
Good afternoon.
Okay, good afternoon.
Afternoon.
Where's Alina?
I don't, she's on now.
Um,
Yes, ladies. And this
Okay.
Candace, yes, send you an email.